Went to, it was Mr. Ramadale.
It was the Mr. Ramadale.
Yes. I can remember him.
Judge, that's good.
Can you hear it, Judge?
Yes, we can hear you now. Thank you.
You're welcome, Your Honor.
All right, sir, you are Mr. Verlinde?
Yes, sir.
All right. We are on the record then in file 23-21206-FH versus Kevin Ryan Verlinde. We are here today on a bench warrant for failure to appear at a show cause hearing for an alleged violation of probation. Sir, you are Kevin Ryan Verlinde?
Yes, sir.
Mr. Verlinde, have you received a copy of the bench warrant?
I have not.
So this is the.
Put it up on the screen for you to read. A moment. Get that. All right, Mr. Verlinde, I just put that up on the screen. You should be able to see it now.
Yes, sir.
Take whatever time you need to read that and let me know when you're finished.
I'm finished.
All right, so the bench warrant alleges that you failed to appear for a show cause hearing with respect to an alleged violation of personal protection, or I'm sorry, violation of probation. The alleged violation is for failing to appear on July 11, 2023. I'm sorry, failing to report to your probation officer on July 11, 2023. Do you understand that the maximum penalty for contempt of court is up to 93 days in jail or up to $7,500 in fines?
Yes, sir.
Do you understand that you had previously pled guilty in this case to failing to comply with reporting duties, and that the maximum possible penalty for that offense is up to 2 years in prison?
Yes, sir.
You do have the right to be represented by an attorney here today and in any other proceedings that we would have in this matter. If you can't afford an attorney, you can tell me that now, and I'll appoint one for you at public expense. Do you understand that?
Yes, sir. I would like one.
Do you want to be represented by an attorney?
Yes, sir.
Do you have the ability to pay for your own?
I do not.
Okay, I have a public defender who can speak with you in a couple minutes. She's working on a different case right now. As soon as she's finished, I will put you in a breakout session with her. Okay, Ms. Underwood, are you ready to proceed with Mr. Arrington?
Yes, we are, Your Honor.
All right. We are on the record in file 23-21440-FH, People versus Tyshawn Jerome Arrington. We are here today for a pretrial conference in this case, and we are proceeding today by video conference. First, let me ask the attorneys to place their appearance on the record, beginning with Ms. Meir.
E.B. Meir on behalf of the people.
Rhonda Underwood on behalf of Mr. Arrington, Your Honor.
All right, Ms. Underwood, where do we stand with Mr. Arrington's case today?
Your Honor, Mr. Arrington is going to plead guilty to count 1 as charged, no subs, and the prosecutor will not be adding a sexual delinquency charge, Your Honor.
Okay, Ms. Meir, is that a complete and accurate statement of the plea agreement?
It is, and just to clarify, we wouldn't be adding it's not another charge, but it's a notice, a sexually delinquent person notice that allows us to sentence him 1 day to life in prison. And we would not be adding that pursuant to this plea.
Mr. Arrington, would you raise your right hand, please? Sir, do you swear or affirm to tell the truth, the whole truth, and nothing but the truth under penalty for perjury?
Swear.
You are Tyshawn Jerome Arrington?
Yes.
You can put your hand down if you like. Mr. Arrington, you've heard the statement of your attorney and the prosecuting attorney. Is it your intention to plead guilty today to count 1, aggravated indecent exposure?
Yes.
Are you satisfied with Ms. Underwood and the advice that she's given you?
Yes.
You understand that the maximum penalty for that offense is up to 2 years in prison?
Yes.
Neither the prosecutor, defendant, or anyone acting on the defendant's behalf has discussed a possible sentence with court. Is that correct, Ms. Meir?
That's correct.
That's
Ms. Underwood?
correct, Your Honor.
Is that also your understanding, Mr. Arrington?
Yes.
If a guilty plea is accepted, there'll be no trial. That means you'll be giving up the rights that you would have had at trial. I'm going to explain those rights to you now to make sure you understand them. You do have the right to a speedy public trial by jury. You could ask for a non-jury trial, and if the prosecutor and the court agreed, you could have a non-jury trial. You have the right to be presumed innocent until proven guilty beyond a reasonable doubt. You have the right to have the prosecuting attorney prove beyond a reasonable doubt that you are guilty, and you do not have to prove anything. You have the right to be present at your trial, to have the witnesses against you appear at your trial, and to ask those witnesses questions. You have the right to have the court order any witnesses that you have for your defense to appear at your trial. You have the right to remain silent during your trial and not have that silence used against you. However, you also have the right to testify at your trial if you wanted to testify. You understand, Mr. Arrington, that if your plea is accepted, you may be giving up the right to appeal issues that would otherwise be appealable if you were convicted at a trial.
Yes.
You also understand that any appeal from the conviction and sentence pursuant to your plea would be by application for leave to appeal and not by right.
Yes.
If you are not a citizen of the United States of America, conviction of a crime can result in deportation, exclusion from admission to the United States of America, or denial of naturalization. Do you understand, Mr. Arrington, that entering a plea to this offense will cause you to be required to register under the Michigan Sex Offender Registration Act?
Yes.
Do you have any questions about any of the rights that I've explained to you?
No.
Do you understand that you're giving those rights up?
Yes.
How do you wish to plead to the charge that on or about May 5th, 2023 in Medina Township, Lenawee County, Michigan, that you did commit the offense of aggravated indecent exposure?
Guilty.
Has anyone made any threats or promises to you to induce you to plead guilty to that charge?
No.
Do you understand that if I accept your plea, you'll be giving up any and all claims that the plea is given as a result of threats or promises that were not disclosed to the court on the record this morning, or that it was not your own choice to enter the plea?
Yes.
Is the prosecutor or defense counsel aware of any promises, threats, or inducements other than the plea bargain to induce Mr. Arrington to plead guilty?
None, Your Honor.
No, Your Honor.
Mr. Arrington, has your attorney promised you any particular sentence or estimated what your sentence would be?
No.
Is it your own choice to plead guilty today?
Yes.
Ms. Underwood, would you like to establish the factual basis?
Thank you, Your Honor. Mr. Arrington, I take you back to May 5th, 2023. Were you a inmate at the Gus Harrison Correctional Facility?
Yes.
And is that facility located in Madison Township in this
Yes.
county of Lenawee in the state of Michigan?
Yes.
And while you were on that date, while you were an inmate at that facility, did you stand on a some sort of object in your cell naked and masturbate while in front of your window while Sergeant Bayer was walking by?
Yes.
And it was your intention to do that?
Yes.
And it was your intention for someone to see you?
Yes.
I believe I've
Right, Ms. Muir, are the
Your Honor.
people satisfied with factual basis?
If we could just clarify what Ms. Underwood means by masturbation. Mr. Arrington, do you agree that you were fondling your own genitals?
Yes.
Okay, I'm satisfied with the factual basis.
Has the court complied with MCR 6.302 B, C, and D, Ms. Muir?
It has.
It has,
Ms.
Your Honor.
All right, I will accept the plea then. It has been given understandably, voluntarily, and accurately. Mr. Arrington has had full knowledge of his rights. He's had competent counsel. Court will refer this matter to the probation department for a pre-sentence investigation, and will set sentencing for December 8th at 8:15 a.m. Mr. Arrington, someone from the probation department is going to be in touch with you to do a pre-sentence investigation interview. When you do that interview, please be truthful about this offense and about your background.
And does Mr. Arrington waive his right to have his sentencing be in person, or does he wish to be brought in person? So I know for writ purposes.
I believe we're likely going to need him in person because we don't have fingerprints for this file. So we're going to have to bring him here in person for the fingerprints.
Okay.
Mr. Arrington is at Gus.
Okay, that's fine. I just needed to know for the writ.
All right, so I am going to sign an order for fingerprints, and we will plan to get that done on the day of sentencing when he's here in person. Okay, then, Mr. Arrington, you can let the officer that's with you know that you're done with court for today.
Thank you.
All right, Ms. Underwood, we have Kevin Verlinde from the jail here. He is our pickup this morning. Do you have his information?
I do, Your Honor. Thank you.
Okay, I'm going to put you in a breakout room with him right now. Okay, Mr. Daly, Mr. Carter is logged in. Are you ready to proceed with his case?
Yes, Your Honor.
How you doing, Mr. Daly?
Doing good.
Okay, we are on the record in file 23-21500-FH. People versus Jeremy Jamal Carter. We are here today for a pretrial in this case. We are proceeding today by video conference. First, let me have the attorneys place their appearance on the record, beginning with Ms. Muir.
Phoebe Mayer on behalf of the people.
James Daly on behalf of the defendant.
Okay, Mr. Daly, where do we stand with Mr. Carter's case today?
We are prepared to proceed forward with trial. I understand there may be an additional charge added that hasn't been added yet. I don't know any more about that than I've heard that may happen. But we are ready to go to trial. The only concern that I have right now, Your Honor, is that Mr. Carter is presently wearing a tether, which makes it's very difficult for him to pay for that tether and to maintain employment, do all the other things he has to do right now. We would ask that that tether be removed. Mr. Carter has appeared every time he is supposed to be here. He drove himself in from Detroit after being stopped on a traffic ticket and found out there was a warrant for him. The police let him go and he drove in here on his own. I don't know what the conflict was as it relates to him not knowing about the charges in the past, but since he's known about this charge, he's made every appearance, he's appeared on time, but he could be in danger of violating his probation if he's not allowed to get rid of the tether that he's wearing, Your Honor.
Who is he on probation with?
Well, he's not on probation now. I meant he was, when he found out he had these charges against him.
All right, how long do you think we need for trial? Just one day?
I think if we could start at 9 o'clock, would it certainly get done in one day? If we start at 10:30, it may go into the second day, but.
Judge, before we address the trial issue, I guess I want to just go back to what Mr. Daly said about our related case. I think it's imperative that we put the offer on the record and make sure Mr. Carter knows what that is before he decides he wants a trial. Right now, he has a financial transaction device felony case pending. That's what this absconding was charged in relation to. We have offered him an attempted use of a financial transaction device with no immediate jail, and that we would dismiss this absconding. So I think it makes sense to at least try that case first. If that's what he wants to do, then to try this case first, because obviously we've agreed to dismiss once we get a conviction on that case. As it relates to the tether issue, though, I mean, obviously he didn't appear at some point, otherwise we wouldn't have this absconding charge. But I guess it is just an alleged absconding charge, but obviously there's something he didn't do that he was supposed to do, and that's why we have an absconding and why he has a tether. So I would just ask the court to consider that.
I think what he didn't do was that there was a miscommunication someplace along the line. I don't think he knew about this. First time he knew about it, he showed up. He doesn't want to plead guilty. He believes he has a meritorious defense. All he wants to do is to continue working and to go to trial when his trial date comes. And it's very difficult to do that wearing a tether. Financially, he'll probably end up in jail if he has to continue wearing that tether.
Well, if the court's willing to set the financial transaction device case first, I think this one is likely to get dismissed either way, whether he's convicted or not convicted of it.
Looks like the financial transaction device case is already set for trial.
Okay, this is Mr. Speed's case, so I wasn't exactly sure.
Sorry, I'm just trying to flip through the register of actions in that other case to make sure I'm correct.
It does look like it's set for trial December 12th, so maybe we can get a pretrial on this after that trial date.
We could do a pretrial during the other
Yeah.
trial.
We'll set a pretrial in this for the same trial date. You said that was December 12th.
Looks like December 12th, yes. 12th and 13th, I'm sorry.
So let's set it for a pretrial on December 12th. And with respect to the tether, at this point, I'm going to deny the request to remove the tether. I understand it is a financial difficulty, but the financial transaction device is a 2019 case. And so, as I probably said when originally ordering the GPS, Mr. Carter was missing from us for an extended period of time, and I just have to have some way that ensures his appearance after he had not appeared and had not dealt with this for a very long time. So that I understand you're raising your hand and you want to try to tell me differently, Mr. Carter, but that's my decision.
Thank you, Your Honor.
All right, so we will have everyone back to the trial on December 12th. Mr. Carter, you can go ahead and log out.
All right, thank you.
Good morning, the gentleman that's at the MDOC facility. Can you tell me your name, please?
Joshua Falls.
Okay, Mr. Folds, your attorney is working with another one of our clients right now, so I'm going to place you back in the waiting room until she's ready to take care of your case. Okay, good morning, Mr. Coyle. I think we have Mr. Padley here.
Good morning, Your Honor.
And let's see. Okay, Mr. Padley, can you hear me?
Yes, sir. Good morning.
All right, good morning. We are on the record now in file 23-21473-FH, People versus Anthony Jacob Padley. We are here today for a pretrial conference in this case. We are proceeding today by video conference. Can I have the attorneys place their appearance on the record, beginning with Ms. Muir?
B.B. Merrimack.
And good morning, Your Honor. Christopher Coyle, P 49708, appearing on behalf of Anthony Padley. who is present by way of Zoom, and we would consent to doing this pretrial hearing by way of Zoom.
Thank you. It appears I have copies of the plea agreement and amended information in the file. Have we reached a plea agreement?
We have, Your Honor.
Okay. Mr. Hoyle, would you like to state your understanding of that plea agreement? Then I'll ask Ms. Muir to confirm.
Yes, so we've worked out with the prosecutor's office and received that amended information, adding a count 3, which is assault with intent to commit criminal sexual conduct in the 3rd degree. And upon Mr. Padley's plea of no contest to that added count 3, the prosecution has agreed to dismiss counts 1 and 2. And there is a sentence agreement and or Killebrew agreement that Mr. Padley would receive no upfront incarceration. I've computed his guidelines on that new amended charge to be 0 to 6 months, and we're ready to proceed in that way.
All right. Is that a complete and accurate statement of the agreement, Ms. Muir?
It is, Your Honor.
Mr. Padley, will you raise your right hand, please? Do you swear or affirm to tell the truth, the whole truth, and nothing but the truth under penalty for perjury?
Yes, Your Honor.
You are Anthony Jacob Padley.
Yes, Your Honor.
Mr. Padley, you've heard the statement of your attorney and the prosecuting attorney. Is it your intention to plead guilty today to count 3 on the amended information? 2nd degree criminal sexual conduct.
It's actually a no contest plea, Your Honor, for.
I'm sorry.
portions.
Yeah, I apologize. Is it your intention to plead no contest today to count 3 on the amended information, criminal sexual conduct, 2nd degree assault?
Yes, Your Honor.
Are you satisfied with Mr. Coyle and the advice that he's given?
Yes, Your Honor.
Do you understand that the maximum possible penalty for this offense is up to 5 years in prison?
Yes, Your Honor.
Other than as we've discussed on the record here this morning, neither the prosecutor, defendant, or anyone acting on the defendant's behalf has discussed a possible sentence with the court. Is that correct, Ms. Muir?
That's correct.
Mr. Coyle?
That's correct.
Is that also your understanding, Mr. Padley?
Yes, Your Honor.
If a guilty plea is accepted, there'll be no trial. That means you'll be giving up the rights that you would have had at trial. I'm going to explain those rights to you now to make sure that you understand them. You have the right to a speedy public trial by jury. You could ask for a non-jury trial, and if the prosecutor and the court agreed, you could have a non-jury trial. You have the right to be presumed innocent until proven guilty beyond a reasonable doubt. You have the right to have the prosecuting attorney prove beyond a reasonable doubt that you are guilty, and you do not have to prove anything. You have the right to be present at your trial, to have the witnesses against you appear at your trial, and to ask those witnesses questions. You have the right to have the court order any witnesses that you have for your defense to appear at your trial. You have the right to remain silent during your trial and not have that silence used against you. However, you also have the right to testify at your trial if you wanted to testify. Do you understand, Mr. Padley, that if your plea is accepted, you may be giving up the right to appeal issues that would otherwise be appealable if you were convicted at a trial?
Yes, Your Honor.
Do you understand that any appeal from the conviction and sentence pursuant to this plea would be by application for leave to appeal and not by right?
Yes, Your Honor.
If you are not a citizen of the United States of America, conviction of a crime can result in deportation, exclusion from admission to the United States of America, or denial of naturalization. Do you understand, Mr. Padley, that by entering this plea, you will be required to register in the Michigan Sex Offender Registration Act?
Yes, Your Honor.
Do you have any questions about any of the rights that I've explained to you?
No, Your Honor.
Do you understand that you're giving those rights up?
Yes, Your Honor.
How do you wish to plead to the charge that on or about February 1st, 2018, in the village of Onstead, Lenawee County, Michigan, that you did commit the offense of criminal sexual conduct, 2nd degree assault?
I apologize. What was your question, Your Honor?
How do you wish to plead to the charge that on or about February 1st, 2018, in the village of Onstead, Lenawee County, Michigan, that you did commit the offense of criminal sexual conduct, 2nd degree assault?
No contest, Your Honor.
Has anyone made any threats or promises to you to plead no contest to that charge?
No, Your Honor.
Do Do you understand that if I accept your plea, you're giving up any and all claims that the plea was given as a result of threats or promises that were not disclosed to the court on the record this morning, or that it was not your own choice to enter that plea?
Yes, Your Honor.
Prosecutor or defense counsel aware of any promises, threats, or inducements other than the plea bargain to induce Mr. Padley to plead guilty?
None, Your Honor.
No, Your Honor.
Mr. Padley, other than as we've discussed here today, has your attorney promised you any particular sentence or estimated what your sentence would be?
No, Your Honor.
Is it your own choice to plead guilty today?
Pleading no contest, Your Honor.
I apologize. Is it your own choice to plead no contest today?
Yes, Your Honor.
All right. How are we establishing the factual basis?
Your Honor, we can stipulate for the record that on or about February 1st, 2018, at a location in the village of Onstead, county of Lenawee, that Mr. Padley did in fact commit an assault with intent to commit a sexual touching of the complainant and or victim in this matter, who's identified as CB, and that she was at the time between the ages of 13 and 17 years old.
All right, Ms. Muir, are the people in agreement with that stipulated set of facts?
Yes, Your Honor.
Are you satisfied that that supports the factual basis?
I believe so, Your Honor.
All right, has the court complied with MTR 6.302 B, C, and D, Ms. Muir?
It has.
Mr. Coyle?
Yes, Your Honor.
All right, I will accept the plea then. It's been given understandably, voluntarily, and accurately. Mr. Padley has had full knowledge of his rights and he's had competent counsel. I will refer this matter to the probation department for a pre-sentence investigation and set sentencing for December 8th at 8:15 a.m. Mr. Padley, someone from the probation department is going to be in touch with you to do a pre-sentence investigation interview. When you do that interview, please be truthful about this offense and about your background.
Yes, Your Honor.
Judge,
Your
I
Honor,
need to get his address and phone number.
I will, Mr. Hadley, and Mr. Coyle, I'm going to place you in a breakout session with Ms. Walsh so she can collect the contact information, and you can go ahead and just leave the meeting from the breakout session if you like.
Before we go into the breakout room, can I make one additional request?
Sure.
Miss Muir and I discussed maybe about a week ago. I had asked or prepared a stipulation in order for an amended bond condition. And I don't know if this court's had an opportunity to look at that and sign it. I haven't heard anything from the clerk's office, but what it is this. I don't have a copy of the stipulation in order in front of me because I'm at a remote site. However, one of the conditions of Mr. Padley's bond is that he cannot have any contact with individuals under the age of 18. Mr. Padley is a manager at Arby's where he's employed, and there are employees that work at Arby's who are 16 or 17 years old. And we're asking for the amended bond condition that he can have contact, of course, with those employees that he works with during employment hours.
And I do show that the order has been filed with the clerk's office. So we were just waiting on a signed copy back from you, Judge.
Can you tell there what date that was filed?
Yes. Should be able to.
Well, I guess not too important. I will, if that's where it is, I can't tell you whether I've seen it and signed it already or not, but we will track it down on our end and find out where.
Okay. Um, yeah, I guess I don't have the date, but it does say it was filed.
Okay. All right, we will track it down on our side and get that to you.
Thank you very much.
Okay,
We are
and
ready
so
for the breakout room.
Okay, 1 second.
Mr. Padley, you know how to join the breakout room?
Yes, sir.
Okay.
Okay, we can go back to. All right, back on the record in file 23-21206-FH, People versus Kevin Ryan Berlindy. Ms. Underwood and Mr. Berlindy are back from the breakout session. Ms. Underwood, do you want to place your appearance on the record?
Rhonda Underwood for Mr. Berlindy this morning, Your Honor. Thank you.
All right, and you know how Mr. Berlindy wishes to proceed today?
Your Honor, at this time, Mr. Berlindy would ask that a not guilty plea be entered on his behalf. And we would ask for a court date as soon as possible on this matter, Your Honor.
Or what kind of court date? Do you want a hearing or?
Probably a hearing. I don't think it would be very long.
Okay, Francis, could you find us a hearing date for a violation of probation and contempt trial? We probably need about an hour.
October 17th at 2:30.
To be this coming Tuesday next week I'm sorry, what time?
2:30.
2:30. Does that work for you, Ms. Underwood?
That's fine, Your Honor.
All right, we'll set it for October 17th at 2:30 p.m.
Your Honor, may I be heard as to the issue of bond in this matter, Your Honor?
You may.
Your Honor, I believe this is a failure to report. Mr. Berlindy has been very involved with issues with his children. Mr. Berlindy also has employment available at, I believe, $250 a day he can make, Your Honor. Mr. Berlindy lives locally. I don't believe his address has changed. We would ask that the court, perhaps with a tether, Your Honor, allow Mr. Berlindy out on bond to address these issues and to begin to economically prepare for his children and to provide support.
All right, so at this point, this is a case, the underlying offense here was failure to comply with reporting duties. On probation, it's alleged that he's failed to report. A summons was issued to him and he didn't appear for the show cause hearing on the summons. So that doesn't give me a lot of confidence that Mr. Berlindy would appear of his own accord. I think the bond as it's set is very reasonable given the situation, and so I'm going to deny the request to modify bond.
Thank you, Your Honor.
I'm sorry, Judge, I missed the date. The next court date for this?
It's October 17th at 2:30.
Okay, Mr. Jones is not available all of next week. Can we move that to the following week possibly?
All right, Francis, do we have something the following week? So we're looking at the week of the 16th.
It would be didn't you say the 17th?
I'm sorry, the week of the 23rd is what we're
Okay.
looking at.
Is this for a trial, Judge? BOP trial?
Yes.
Okay.
Would you like that backed up to anything, Judge? Next week, you have the Timothy Ellenwood trial.
Yeah, we don't want to back it up to that, I don't think. Fairly confident that that's going to go.
You could do 2:30 on Wednesday, November 1st.
All right, so we'll set it for November 1st at 2:30 p.m.
Thank you, Your Honor.
All right, give me just a second here. All right, given the length of time and that we're not able to accommodate Mr. Verlinde with a trial next week, I think it's more appropriate if we're going to have to wait closer to a month to modify his bond. So I am going to, at this point, change that to a PR bond with a GPS tether.
Thank you, Your Honor.
Thank you, Your Honor.
All right, Mr. Verlinde, you can let the officer that's with you know that you're done in court for today. You need to be back here in person on November 1st at 2:30 p.m.
I will be there. Thank you.
All right, thank you. Okay, can you hold for, let's see, Ms. Underwood, I have Mr. Sneed here. Do you need a breakout session?
Sorry.
Do you need a breakout session with Mr. Sneed?
I don't believe I do, Your Honor.
All right, we're just waiting for Mr. Sneed to get his audio connected. All right, Mr. Sneed, can you hear me?
Yes, can you hear me?
Yes. All right, we are on the record in
There's two files,
In
Judge.
in file 23-21455-FH and 23-21456-FH, People versus Matthew Eric Edward Smead. Both of these are set for pretrial conferences this morning, and we are proceeding today by video conference. First, let me ask the attorneys to place their appearances on the record, beginning with Ms. Brenner for the people.
Good morning, Your Honor. Sarah Brenner, Assistant Attorney General for the People.
Ron Underwood for Mr. Smead this morning, Your Honor.
All right, Ms. Underwood, where do we stand with Mr. Smead's cases?
I have talked to Ms. Brenner and Mr. Smead. Mr. Smead has new employment, Your Honor. Where is that, Mr. Smead?
It's for 2 men in a truck.
2 men in a truck, Your Honor. Ms. Brenner has very kindly agreed, Your Honor, to give us a short adjournment to allow Mr. Smead to have the proper documentation for income withholding done, Your Honor. So we would ask for a short adjournment, maybe a month.
It's already been turned in. I've already received paperwork in the mail. I got it yesterday. I got it sitting right here in front of me.
Yep. So I just want to see payments coming through.
That won't be an issue. That as soon as I start getting paid, I ended up with very sick. I was supposed to start October 2nd. So I had to push my start date back because we didn't know if we had COVID or not. So I had that was all clear. And another thing is I would like a new attorney because she has not asked. This is the first time I've even talked to her on the phone. She didn't ask me the last court date, what job. She just threw 2 random jobs out there. And I'm not very appreciative of that. That represented me very well.
All right, Mr. Smead, if you, you've been appointed a public defender in this case. If you are not satisfied at this point with your public defender, you need to contact the public defender's office and address that issue with them.
Okay.
Well, and Your Honor, I can state for the court that I was not going to agree to the adjournment, but Ms. Underwood convinced me to do that today. So I can tell Mr. Smead that. So, but I am agreeing to the adjournment so that he can start making payment efforts per my discussion with Ms. Underwood.
All right, so we're going to adjourn this out to make sure that payments actually start coming in. How far out, Ms. Brenner, did you want to look?
Can we do like 45 days, Judge, so I can see a couple of weeks of payments coming through?
I get paid bi-weekly.
All right, so that takes us to about the end of November, I guess. How about November 29th at 8:15?
Thank you, Your Honor.
All right, so Mr. Smead, you'll need to log back in next time on November 29th at 8:15 a.m.
Okay.
Thank you, Your Honor.
Let's see, Ms. Underwood, would you be willing to do a stip-in order for the adjournment?
I will be happy to do that, Your Honor. Thank you.
Thank you, Rhonda.
All right, thank you. Mr. Smead, you can go ahead and log out. Ms. Underwood, I have let's see, Joshua Folds from the from MDOC. Do you need a breakout session with him?
I do not, Your Honor. Thank you.
No, maybe I don't have Mr. Folds. Oh, yeah, there he is. Sorry, Ms. Underwood, you said you do not.
I do not, Your Honor.
Okay. All right, we are on the record in file 23-21481-FH, People versus Joshua Dwayne Folds. We are here today for a pretrial conference. In this case, we're proceeding today by video conference. First, let me have the attorneys place their appearance on the record, beginning with Ms. Mintz.
PB, Mayor on behalf of the people.
Rhonda Underwood on behalf of Mr. Folds.
Okay, Ms. Underwood, where do we stand with Mr. Folds' case today?
Your Honor, as I told Mr. Folds and we discussed when I talked with him, we do not have the criminal responsibility done yet on this matter, Your Honor. So we're going to ask for another adjournment.
All right, Ms. Muir, anything to add from the people's standpoint?
I'm showing that they did do that and we have a finding in order. Is
On
there
criminal responsibility?
it back in May?
I believe that was competency.
Okay, all right, maybe it is, that's fine. I guess no, then nothing to add. They didn't do it at the same time, Ms. Underwood?
They are not doing them at the same time.
Okay,
Just found, yeah, it's a finding order on competency from back in July. And usually the competency takes maybe 60 days. The criminal responsibilities unfortunately have been taking significantly longer than that.
okay.
I guess we don't really have a choice but to adjourn the case.
I Miss Underwood.
Let's go with November 22nd at 8:15 a.m.
Thank you, Your Honor.
Ms. Underwood, would you do that step in order, please?
I would be happy to do that.
Mr. Folds, you need to speak with Ms. Underwood.
I wanted to ask you something, Judge.
Oh, okay. Then can we have a brief breakout? Your Honor?
Okay, let me have you talk to her first and make sure that she wants you to be able to speak on the record, okay?
Yes, sir.
Can we have Mitchell drop and sit in the room for the judge, please? Thank you. Bye.
All right, Ms. Underwood, where do we stand with Mr. Folds?
Mr. Foltz had a question about the criminal responsibility, Your Honor, and I think we're good.
Okay, Mr. Folds, then you can let the officer that's with you know that you are done with court for today.
All right, sir. Thank you. Y'all have a blessed day.
Thank you, you too.
Have a blessed day, Miss Underwood.
You too.
Okay, Ms. Underwood, we have Mr. Torres here in the courtroom.
Thank you, Your Honor.
I think he would like a breakout session with you.
All right.
Yeah, it should be already. Yeah, all right, Mr. Torres, if you want to step outside to the hallway. So Sergio, I'm gonna need someone to turn on the video and unmute the iPad out there. Oh. Mr. Simmons, I have someone else that that needs to use the iPad right
Okay.
now.
The sound wasn't on. Yes, all right.
Okay, yeah, we're all set now.
Judge,
We're good.
we're all set? Okay, there you go. This is Rhonda. Hello?
Okay, Mr. Fry, Ms. Walden was, I think.
She is here.
Oh, she's here in the hallway. Mr. Fry, are you gonna need a breakout session with her?
That'd be helpful, Your Honor.
Okay, we're gonna have to wait in line for the iPad then. I just want to try to fix it. Okay, Mr. Robinson, your attorney is working with another client right now. As soon as she is finished, we'll get to your case, okay?
Yes, sir. Yes, sir.
Mr. Murphy, Caleb Rowell is not logged in and not here in person that I'm aware of.
Okay, Your Honor, I just talked with him yesterday. I'll try to call him over the phone if you give me maybe 10 to 15 minutes, please.
Sergio, could you go ahead and Ms. Walden step on the line? All right, Ms. Walden, I'm going to place you in a breakout session with Mr. Fry so you can speak to him.
Okay.
Good. Mr. Amadeo, we don't have Mr. Tatcher logged in from.
He's at Gus Harrison, Judge.
Yeah, I've got somebody trying to call them right now to see if get him around.
And if need be, I could waive his appearance today. I don't know if you want to do that, but I submitted a COPS on, but maybe a copy of. So I just need a couple week adjournment for you to review, see if you want to do anything with that.
Okay.
I just got his medical records to become a release. He gave me permission.
So is there anything you need to do on the record with him?
I guess just a 2 week adjournment. I could do a stipend order.
Okay.
And I could give you this hard copy if that's acceptable, Judge.
That'd be fine. You go with October. Yeah, so 2 weeks with the October 25th.
9 a.m. Your Honor, or 8:15?
8:15.
So. Judge, here's a hard copy. Here with you. If it's not enough time in 2 weeks, you can always get another date, but I just got all his medical records, so my plea is for leniency based upon that. I gave a copy to the prosecutor.
Okay.
Also, the old house, the matter I provided a stip to circuit court.
Oh, yeah.
Your court approved that, I decided to give a stip.
Yep, I think I signed.
Okay, and I'll get you a stip for this then for 2 weeks?
Yep, that'll be
Okay,
great.
thank you, Your Honor.
Okay. All right, Mr. Torres, you want to come forward and sit at the table here, please? Okay, let's see, we're on the record in file 23-21561-FH People versus Paul Manuel Torres. We are here today for an arraignment in this case, and we are proceeding today partially in person and partially by video conference. First, can I have the attorneys place their appearance on the record, beginning with Ms. Meir.
BB Mir, on behalf of the people.
Rhonda Underwood on behalf of Mr. Torres this morning, Your Honor.
And sir, you are Paul Manuel Torres?
Yes, sir.
All right, Ms. Underwood, does Mr. Torres wish to have the information read?
We would waive the reading of the information, Your Honor. Acknowledge its receipt and the receipt of the witness list and request for discovery, Your Honor.
Okay, and how does Mr. Torres wish to plead today?
Your Honor, it's my understanding that the offer in this matter is a second. I just discussed that Mr. Torres would like to do sobriety court. I don't know if there's a amended complaint with a second on it drawn up, Your Honor. I do know that the judge for sobriety court is out for a couple weeks. So I think probably for expediency, maybe if we put it over for a plea next week, we could have the amendment drawn up, and then Mr. Torres could proceed down to sobriety court.
All right, Ms. Meir, anything to add from the people's side?
Has he been screened for sobriety court?
Yes, yes, he has.
And he was accepted?
Yeah.
Okay, then yeah, I guess I would agree to an adjournment and we can prepare an amended information.
Okay, let's adjourn it then to next week, October 18th at 8:15.
Thank you, Your Honor.
On the amended information at that time.
And just for the paperwork, we would ask for Mr. Torres to stand in at this point today, Your Honor.
Yep, thank you. So we'll enter a not guilty plea for Mr. Torres instead of pretrial for next week, October 18th at 8:15 a.m. Thank you, Mr. Torres. You're all set for today. You just need to either be back here or you can log in on Zoom next week at 8:15 a.m.
Okay, sir. Thank you, Connor.
Thank you. All right, Mr. Fry, are you ready to proceed with Ms. Walden?
Yes, Your Honor.
Ms. Walden, please come forward to table. We are on the record in file 23-21485-FH, People versus Kimberly Ann Walden. We are here today for a pretrial conference in this case, and we are proceeding partially by Zoom and partially by video conference. First, let me have the attorneys place their appearance on the record, beginning with Ms. Muir.
B.B. Mir on behalf of the people.
Brian Fry on behalf of the defendant Kimberly Walden.
All right, and Ms. You are Kimberly Walden?
Yes, I am.
Okay, Mr. Fry, where do we stand with Ms. Walden's case today?
Your Honor, we would request a short adjournment of the pretrial. A few weeks if possible, just depending on what this court schedule is. Basically, we think we might have this case close to resolved from discussions I had with Mr. Prosecutor Fleming, who's out of the office for another couple of weeks, I think. So if we could set this out to when he comes back, we might be able to get this resolved based on my conversations with him in district court a couple of weeks ago.
Okay, Ms. Muir, anything to add from the people side?
I think if we get a pretrial in November, we should have enough time for that. Mr. Fleming will be back and we'll be able to look at it.
All right, we could do November 8th at 8:15.
That works for me, Your Honor.
All right, Mr. Fry, would you be willing to do a stip in order for that adjournment?
Yes, I can do that. Ms. Muir, could I sign your name to that stip with your permission?
Yeah, no problem.
Thank you.
And all right, so Ms. Walden, you'll need to be back here either in person or by Zoom on October 8th at 8:15 a.m.
Okay, thank you.
Okay, thanks. Ms. Underwood, do you need a breakout session with Mr. Robinson? Ms. Underwood, are you there? Ms. Underwood, are you there? She apparently stepped away from her desk for, oh, no, there she is. I was not able to hear that, Ms. Underwood, for some reason.
I'm here, Your Honor.
Okay, do you need a breakout session with Mr. Robinson?
Okay, yes, Your Honor. Thank you.
1 second, I've got to close the existing one and then I'll get you put over there.
Thank you.
Your Honor, Mr. Robinson is Mr. Glazer's.
Oh, I'm sorry. All right, Mr. Robinson, I'm sorry. So Mr. Glazier, he was logged in earlier, but he is not logged in at the moment. He's probably over handling a case with Judge Anzalone. So as soon as he gets logged back in here, I'll have you speak to Mr. Glazier.
You want me to stay here then?
Yeah, you can stay there, please.
Yep.
Your Honor, do we have Mr. Nash?
I do not have Mr. Nash logged in, and he's not here in the courtroom. There's no one here in the courtroom.
I believe it's an MDOC. Maybe we
That's an MDOC case.
maybe we signed in a waiver. Maybe we waived it.
I don't see that that one was waived. Yeah, we do have a writ for him, but he is not logged in.
Okay.
Do you want to set it out and try another writ?
Yes. Yeah.
Let me just go on the record real quick so we can have a record of it.
Yep.
All right, so we are on the record in file 23-21552-FH, People versus Dominic Narvell Nash. This is set for an arraignment this morning, and we are proceeding today by video conference. And I first have the attorneys place their appearances on the record. Ms. Muir, are you there?
Yes.
Can you place your appearance on the record? This is People versus Dominic Nash.
Sorry, I thought this was Mr. McCready's case. I thought he was logged in, but Phoebe Miram have the people.
Ron Underwood on behalf of Mr. Nash this morning, Your Honor.
All right, I've had a brief discussion off the record with Ms. Underwood. Mr. Nash is not logged in from his MDOC facility. Looks like according to the writ, he is located at the St. Louis Correctional Facility. We had a writ for him to appear by Zoom today, but they have not logged in with Mr. Nash. So we are not able to proceed with the arraignment today. What I will do at this point is adjourn this to October 25th at 8:15. And we will proceed with the arraignment at that time, assuming that we have Mr. Nash present.
Thank you, Your Honor. I know Mr. McCready and I have talked about this case, so I think we're right on schedule aside from this. Thank you.
Okay, thank you. Okay, Mr. Rowell, your attorney, Mr. Murphy, he is not in my Zoom session right now. He's probably over taking care of some cases with Judge Anzalone. So as soon as he's logged in here, we will get to your case.